Good evening to everyone. My name is Randi Surya. I'm the treasurer for IEPSL. So in the absence of President, I would like to welcome all of you for this timely topic to discuss today. Some of you may know about IEPSL, but for the benefit of everyone, I will very briefly explain whom we are, what are we doing, what is the scope of disciplines that we are in. IEPSL is the umbrella organization for environmental professionals, which was actually started in 2006 from a cabinet decision. And a couple of years back, we became an institute under the Parliament Act. So there was a need some time back. There are many professional institutes, but nevertheless, there were no umbrella organization to talk about environment, sustainability, and related topic. Because environment professionals can come from any professions. We are an engineer, scientist, lawyer. So that's the intention of creating environment professionals to create that umbrella organization who would like to join. So with that, I would like to give the forums to Trishan, if I may briefly explain about who Trishan is. Trishan is our assistant treasurer, very dynamic fellow for IEPSL for many years, who's currently the manager of University of Business Link Cell of University of Jawaharlal and director of Empower Sri Lanka. And Trishan is the computer today. Over to you, Trishan, and wish you all the luck for everyone.
Yeah, thank you. So I would like to welcome you all and good evening to all of you joining for the Human Rights Day 2023 webinar. In commemoration of this significant day, our virtual gathering aims to deliver indicate connection between the environmental issues and the fundamental principles of companies of esteemed speakers, expert in their respective fields. Ready to share valuable insights and engage in thought-provoking conversations. I encourage each of you to actively participate, ask questions, and contribute to the enriching conversations. And you can post your questions into the chat box. And I would like to introduce our first speaker of the day. And she will talk about equity and non-discrimination at the heart of sustainable development. She is none other than Professor Kokila Konasinghe, Head of the Department of Public and International Law and founding director of the Center for Environmental Law and Policy, Faculty of Law, University of Colombo. Professor Kokila, over to you.
Thank you very much, Trishan. And let me first of all thank this Institution of Environmental Professionals, Sri Lanka, for inviting me to share my knowledge on this, which I always delighted to do. And also, I have another partner with me today, Ms. Thushini Jayasekera. Thank you, Thushini, as well, for being partnering with me in this initiative. Thank you. And also, Dr. Janaka Jayasekera, thank you very much for inviting me to deliver this talk. Right. So I think, first of all, let me share my presentation. Thank you very much for joining with us today for this very important discussion, which I believe that we must do very often, educating and making awareness of environmental protection, particularly on environmental law, because not many of us are aware of environmental laws, but we all are supposed to know law. That's a presumption that in law that we believe that everybody should know law. So with that approach, let me first start with my presentation, and I hope you can see the presentation. Trishan, can you see the presentation?
Yes, I can see the presentation. Okay.
I go on, and my area of discussion today is equality and non-discrimination at the heart of sustainable development. Now, with my title, one might wonder what I am doing here with my expertise in environmental law at this forum, which is about commemorating of Human Rights Day 2023. And the theme of this entire forum is dignity, freedom, and justice for all. Now, how would I bring environmental green elements into this whole spectrum of discussion on human rights? Very simple. One can answer. We all are human beings. So when speak about human rights, there's a very close connection with the environment, as we all are species who live on this planet, sharing the same resources. Right. Let's start with that very broad understanding. And at the end of my presentation, I will take you to a very controversial and also thought-provoking area of environmental law, which also tells us that it's not only about human rights, but there are much more things to explore in this environmental law discourse. So with that, I think we will move on to the understanding of these concepts, themes, which is equality, non-discrimination, and sustainable development. Let me invite you to spend 1 minute thinking yourself, what do you mean by equality? What do you mean by non-discrimination? And what do you mean by sustainable development? Just take 1 minute to think and reflect on what do you understand by these terms. Right. What is equality? Now, here I thought that I should first set the background for human rights, understanding human rights concepts, and then move on to my area of expertise, which is environmental law, and how to see the interconnection between environmental protection and human rights perspective. Have you ever thought that equality and what it means? Now, it's very easy for us lawyers to interpret equality because we have the main source of law, the prime law of the country, which is the Constitution. In Article 12(1) of the Constitution, it says, all persons are equal before the law and are entitled for the equal protection of the law. So it is very clear that because it's about fundamental rights and it's about human rights, so we focus straight away with the human beings. So all persons very clearly states all persons are equal. Now let me move on to non-discrimination. What does it say? It is slightly different from equality. Equality provision is very broad and the scope is very wider, which includes all persons are equal before the law. When it comes to non-discrimination, we say no citizen shall be discriminated against on the grounds of race, religion, language, caste, sex, political opinion, place of birth, or any one of such grounds. Now, you can let me bring your attention into the second word of this article, citizen. As you can see, when equality comes to non-discrimination, there is a slight limitation that is limited only guaranteed only for citizens, right? So equality, very wide, all persons. Even if a tourist is here for a short time, he is also covered with Article 12.1. He should be, he is equal before the law and he should be treated, he is entitled to equal protection of the law. But when it comes to non-discrimination, it has to be a citizen. And then this Institute of Environmental Professionals requested me to do a presentation where equality, non-discrimination in the heart of sustainable development. Now, my challenge is how we are going to look at this connection. At the heart of sustainable development, how do we ensure equality and non-discrimination? Therefore, I thought that I should also define sustainable development. Setting out a new paradigm for more inclusive of sustainable development is what it says in 2016 Committee of Executive, the UN Committee of Executive Board, they have this document report on sustainable development and its application. And this is how they said, setting out a new paradigm for more inclusive and sustainable development. So this inclusivity also has connection with equality and non-discrimination. And what is sustainable development? The definition is given. Sustainable development is development that meets the needs of the present without compromising the ability of future generations to meet their own needs. Now you can see, first we had all persons, and then we had citizens. And when we talk about sustainable development, it's about present generation and future generations as well. So things are a bit complicated when you look at all of these concepts on one platform. How do we ensure equality, non-discrimination for future generations when they utilize natural resources which the present generation has the authority on? Because we are using it for our benefits at present. But it is very clearly says that the present generation has the responsibility to meet its needs in development without compromising the ability of the future generation to meet their own needs. So this entire scope of sustainable development stress the importance of making equitable sharing of natural resources. Therefore, I think this is very important that an institute that is dedicated for environmental professionals wants to discuss about human rights perspectives and bringing the sustainable development concept to it. Environmental protection is a platform where you can discuss bringing many other multidimensional areas. Therefore, sustainable development, as we see, there are three main components. We all know it. It's fundamental to sustainable development. What are the three areas? Environmental issues, economic issues, and social issues. So we believe that all these three, it's like a three-leg table. So if one leg is broken or imbalanced, the entire table can't stay stable. It will collapse. So we need to maintain a proper balance among these three concepts: social issues, economic issues, and environmental issues. Now, when we do this, the most important thing is that we need to maintain equality and non-discrimination. Now, when we make priorities, when we make decisions, we need to make priorities. When we make priorities, there are certain instances that the government or the ruler or the public officers needs to make priorities and make certain decisions with regard to natural resources, sharing of natural resources. How can we make this sharing equitable and fair to everyone? Now, in this discourse, I think we need to look at these concepts: equity, justice, fairness. Equity, justice, fairness are very much interconnected with equality and non-discrimination when sharing natural resources. So I have mentioned here, development must be more equitable if it is to be sustainable. Development must be more equitable if it is to be sustainable. So sustainable development means it needs to be equitable, because equitable sharing of natural resources should be ensured in any course of sustainable development. Now, let me take one example to explain this. We all know that in the global priority list, now the climate change has become the #1 priority over even the global security, because every human being living on this planet knows that the threat is immense and imminent. So the solution for climate change should also be universal and also collective, and a quick decisions should make in order to face the climate change challenge. Now we know that these decisions are made based on environmental law concepts, which I will talk to you in a minute. And these decisions are always need to analyze that equity and justice and fairness. Now, a very good area to look at these 3 or 4 or 5 components: equality, non-discrimination, equity, fairness, and justice, is climate justice. When climate change create adverse impacts for human beings, there is this issue of climate justice arise. So climate justice is another very important area where you see very clearly inequality, injustice, and unfairness. Therefore, I thought I should highlight this example, climate justice, and then show you what we should aim to achieve in order to achieve equality and non-discrimination in the scope of climate change, that which is a sustainable development component, and also climate change, sustainable development goals, and also very much highly considered environmental issue. Now, equality and also decisions with regard to climate change should be transparent, and also there should be meaningful participation. So in my first slide, I mentioned inclusivity. This is what you mean by inclusivity: meaningful participation. Now, if I take the example of EIA, Environmental Impact Assessment, that many of us are very familiar with. In this environmental impact assessment, we have a stage called public consultation. public consultation process, where we consult the public that may have adverse impact if this so-called the major development project is implemented. We consult the public. So that's a public consultation process. Now, is this meaningful participation? Have the public been prior informed? Do they know on what grounds they should contribute? And also, do they understand the EIA report? Can they read the EIA report and understand? Is it clear? Now, all of these are very practical questions that we face when it comes to this meaningful participation. We all know that in the law, according to National Environment Act, number 56 of 1988, the Amendment Act to number 47 of 1980 Act, introduced, Section 23 introduced this environmental impact assessment system, which is recognized as a very good standard process to evaluate environmental impact in a major development project and then make the development project more sustainable one, right? So EIA is a sustainable development tool. Some scholars even call EIA a sustainable development tool. Now, in this tool, we use this stage called public consultation process. Now, do we do this as a meaningful participation? Do we facilitate meaningful participation? The EIA report is written in a very highly technical language. And I don't think there are very readily available translations. So sometimes, even though we say even a layman can go and give their opinion about a development project at a place where the EIA is open for public consultation, do we really think that it is meaningful participation? I think we should think further, explore further in this regard. And as I mentioned you, that there are certain environmental law concepts and principles that makes impact influence through to environmental decision makings. In environmental law, we have legally binding international laws such as convention, treaties, and also non-legally binding legal instruments such as declarations, soft law documents. At the national level, we have acts, statutes, case law, judgments, regulations. But the most influential part of environmental law lies on concepts and principles. That is something unique about environmental law. They have set of international environmental law concepts and principles. Actually, if you look at conventions, principles, treaty provisions, and also if you look at provisions in a statute, you will see that these concepts and principles are the base, the fundamental base of those provisions. So this has enormously impact to case law, judgments, as well as provisions in the statutes, acts, and treaties. What are these? Intergenerational equity principle, intragenerational equity principle, common but differentiated responsibilities principle, state sovereignty and state responsibility. In addition to these principles that I mentioned here, there are some other principles such as public trust doctrine and polluter pays principle, precautionary principle, and some other principles. But I did not want to include those here because I deliberately chose these concepts and principles because my main area of today's discussion is equality and non-discrimination. So I selected the international environmental law concepts and principles that are directly relevant to equality and non-discrimination. So what is the interrelation of sustainable development with other environmental law concepts? Intergenerational equity. I just mentioned the definition of sustainable development, which explains to make an equitable sharing of resources between present generation and future generation. That is what you call intergenerational equity. So whatever the decisions you take at present should reflect that you consider equitable sharing with the future generations. In Sri Lanka, there is this nursery rhyme in Sinhala says, මේ ගහේ බොහෝ පැණි දොඩම් තිබේ පැහිලා ඉදිලා බිමට නැමිලා බර වෙලා අතු නංගිටයි මටයි ගෙඩි දෙකක් ඇති වැඩිය කඩන නරක ළමයි හිම නොවේ අපි. So I think this reflects this equitable sharing. There can be ample of enough sufficient natural resources at places, but should we use it? Or should we think about the future generation? So can we use it for our own usage at present generation? Or should we think of equitable sharing? So this is intergenerational equity. Intragenerational equity means within a present generation, within this generation, there can be many inequities, many inequalities. Particularly, we all know that this difference between North and the South, developed countries and developing countries. In every environmental debate, climate change, whether it is Vienna Convention on ozone depletion, biodiversity, we see this conflict, intra-generational equity. Within a generation, there are so many equitable or these problems and issues, concerns with equity and equality. So intra-generational equity is also important principle in international environmental law. And common but differentiated responsibilities, you might have heard this before. Common but differentiated responsibilities states that environmental problems are common. We all know that they are transboundary, they are universal, global problems. Whatever happened in Sri Lanka can make an impact in New Zealand. So this is all connected. So problem is common. But the differentiated responsibilities. Responsibility should be different depending on what? Depending on the capacity. Otherwise, what will happen? If the responsibility is also common, what will happen? That will violate the equitable principle. That is not equity, that is unfair. So therefore, this common but differentiated responsibilities emphasized in Vienna Convention on ozone depletion, as well as United Nations Framework Convention on climate change. They have recognized these different responsibilities between OECD countries, industrialist countries, and the third world. So they recognize, they give flexible measures, flexible standards to the developing countries, long-term standards. But for the developed countries, they set strict standards, short-term goals. So if the developed countries are required to convert their refrigerators CFC-free within 3 years, then the developing countries have the flexibility for 15 years, like that. Even in climate change, we have Annex 1 country, Annex 2 country. So we have recognized the difference. Common, the problem is common, but the responsibilities are different. State sovereignty and responsibilities also reflect certain north-south dimension, and the southern countries have certain level of protection and certain level of demand towards more financial assistance and also technical transfer expertise. So these environmental law principles I mentioned, just to mention that how to make this interrelation between sustainable development and these environmental law principles. Right. Now let me move on to the second part of my discussion, a conceptual analysis on a different account. This is where my green part comes in. My environmental law understanding tells me that human rights provisions always look at from the anthropocentric approach, which means the natural resources are resources are limited, and we need to make decisions with these limited resources. And who's getting the most attention and who is in the center of the focus when making decisions on natural resources? Human beings. What do we call this? There's a very beautiful Greek term called anthro, human-centered, anthropocentric, human-centered approach to natural resources. Anthropocentric approach. Environmentalists have another fascinating concept called ecocentric or biocentric, which means we look at the entire ecosystem, biosphere, when we make decisions with regard to these limited resources, environmental and nature resources. Now, this anthropocentric approach says all to human beings, but the nature is excluded when we say all human beings have right to whatever. So the human rights approach always look at from the human beings perspective, rights of the human beings, rights of the humans. But when we say that this everybody or all should be protected and all are equal before the law, this all can also consider nature. Dignity, freedom, and justice, all of these words can also be related to humans as well as nature. Now, this is a paradigm shift in environmental legal discourse and environmental law and human rights perspective discourse. This paradigm shift is there now. More and more arguments and debates, discourses are happening at the global level with rights of nature concept. Right. So rights of nature concept says that sometimes natural objects also can go to court. Now you might think, many of you may be scientists, science from other backgrounds. You might think this lawyer comes and gives us ridiculous arguments on the nature can go before the court. How can that be? Because it should always be a natural person or a company like legal entity. But now this rights of nature concept states that when you look at right-based approach to environment, nature too has right to evolve, right to be protected, right to be conserved. This particular argument has now come in the form of constitutional guarantees. In Ecuador, Article 71 of the Constitution states that nature has right to evolve, be protected, and conserved. That is a constitutional guarantee, mind you, meaning the prime law of the country, supreme law of the country, guarantees you a fundamental right to nature. And in there are other jurisdictions which have acts, statutes on rights of nature perspective. One such statute in New Zealand, 2017, Whanganui River Settlement Act, states that the Parliament has passed this act, Whanganui River Settlement Act, stating that River Whanganui is a legal person. So the legal personality is granted for a river. And also, that is the statutory provisions. Previously, Ecuador is the constitutional provision, and there are series of judgments by the judiciary granting rights of nature. In India, Uttarakhand High Court in 2017 granted 2 cases, Ganga and Yamuna, rivers, legal personality. And also in Bangladesh, Turag River, there was a case, and then the Court of Appeal granted legal personality to all the rivers in Bangladesh. Likewise, we have another set of judgments coming up that rights of nature approach to legal personality. Now, this means human beings either versus nature or human beings and nature should take into consideration when we discuss about right-based approach. So I think this is where I will stop, and any questions, comments, or clarifications are most welcome. I want.
Thank you, Professor Kokila. And I would like to invite our next speaker, Ms. Thushini Jayasekera, attorney at law and LL.B. honors, and LLM in, she's reading the LLM in international law, and she's the legal officer from Center for Environmental Justice. So she will talk about Sri Lankan perspectives of human rights and sustainability. Ms. Thushini Jayasekera, over to you.
Yeah, thank you so much, Trishan. First of all, I would like to thank Institute of Environmental Professionals in Sri Lanka and Mr. Janaka Vijayasekara for giving me this wonderful opportunity. And also, I would like to thank Professor Kokila. She's my teacher, and it's a great pleasure to have this discussion with her. So let me begin my presentation. I'm going to talk about Sri Lankan prospects of human rights and sustainability. I know Professor Kokila delved into several concepts So to initiate my presentation, I also want you to think about human rights. What are your human rights and the concept of sustainability? Have we gained the sustainable development as a nation? So I give you 1 minute to think about these things, and I'll discuss with you through my presentation what are the human rights and sustainability. Yeah, since I've been given a limited time, I know Professor Kokila also explained what is the human rights. Human rights are the rights we have simply because of we exist as human beings. They are not granted by any state. They are getting just because we are human beings. As individuals or humans, we are entitled to set of human rights such as right to life, right to health, right to equality, and there are many more. If I given a chance to list down the human rights, there are a number of human rights. So I want you to again think about sustainable development. Sustainable development, we simply define as a development that meets the needs of the present without compromising the ability of the future generation to meet their own needs. Having said that, next I want you to think between the interconnection between the healthy environment, right to healthy environment, and human rights. We are all rely on environment where we live to fully enjoy many human rights like life and health, food, water, and sanitation. We need a safe, clean, and sustainable environment. Without a healthy environment, without a clean environment, we can't achieve the sustainable goals and also the dreams that we are pursuing. To achieve sustainability, especially we need to guarantee the environmental human rights. What are our environmental human rights? Right to live in a healthy environment, right to life and health, right to equality, right to water and sanitation, right to food, climate justice, and right to information. These all the rights are interconnected, which is directed to the sustainable development. So this right, having access to information is crucial because clear data or the correct data keeps the government to understand, ensure the public's right, and it prevents the corruptions, as well as when we talk about the right to live in a healthy environment. When the environment is polluted, it can harm our health, and also everyone should have the right to live in a healthy environment and have the clean air and water. So that is I'm telling you that these rights, these environmental rights, directly connected to the sustainable development. As humans, we are our environmental human rights getting violated in many ways, such as water and soil and air pollution, deforestation abuse, deforestation and exploitation of natural resources, nuclear testing and chemical experiments. This is not common in Sri Lanka, but this nuclear testing and chemical experiments is a huge issue in the global sphere. And also the usage of pesticide, disposing medical waste and factory waste to water courses and our soil, improper management of waste. So through these ways, our environmental human rights get violated, as well as our environment day by day getting degraded. Having said that, I want you to, I have included a site to showcase the global community's perspective on importance of environmental human rights. And they have emphasized the key treaties such as Rio Declaration, Principle 1 of the Stockholm Declaration. It has mentioned that man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of quality that permits a life of dignity and well-being. So these are all about our environmental rights, and it implies the sustainability gained through these environmental human rights. And also I have mentioned here Principle 1 of this Rio Declaration. It has mentioned that human beings are entitled to healthy and productive life, and in harmony with nature. So these are the international concerns, and through those international concerns, I want you to think about next, what is the Sri Lankan context? What is the local context of environmental rights, or right to live in a healthy environment, or at least right to life? So what do you think? Do we have the right to live in a healthy environment, or right to life, or the protection of the environment? So I invite you to think a bit about this. So under Constitution of Sri Lanka 1978, if you are a human right person, we don't have fundamental right to live in a healthy environment as a fundamental right. As well as, we don't have the right to life under our constitution. Then how can we demand our right to live in a healthy environment or even right to life under the constitution? Because it is not guaranteed under our constitution as a fundamental right. So however, when we talk about this right to live in a healthy environment or right to life, I'm telling you, we have interpreted right to life under some case laws, though we don't have right to life under our constitution. For example, Shriyani Silva versus Iddamalgoda case, they have interpreted right to life under can be interpreted under the right to equality, which is Article 12(1) of the Constitution. Yeah, as I said previously, we don't have right to life, right to live in a healthy environment under fundamental rights or fundamental chapter. But still, they have given us state directive principles. They have mentioned state duty as well as the public responsibility towards the protection of environment. Article 27 of the Constitution, it has mentioned that state has a duty to protect, preserve, and improve the environment for the benefit of the community. As well as Article 28, it is not only about the state responsibility or state duty, but also as public, as citizens, we have the responsibility to protect our nature and conserve its riches. So that is when we talk about this environmental protection, environmental human rights, this particular Article 27 and 28 is really important because as I told you previously, we don't have right to live in a healthy environment or right to life under our constitution. I see it as a really big gap in our law. Yeah, and I want you to next think about the access to information, because when it comes to environmental protection, environmental rights, as well as human rights, we need to right to information. Before 19th Amendment, we didn't have the right to information. However, there are some instances that it has been accepted that right to information recognized under Article 14A, such as Goldface Green case. As well as, I want you to tell you that now we have right to information under 19th Amendment. So this is a great victory, I would say, because having clean and correct data, we can see we can question the transparency of the government or the corruptions of the government or the government institutions. And also, what do you think about right to participate in environmental decision making? Do we, we don't have right to participation in environmental decision making, and Professor Kokila also discussed about this thing. But as she mentioned, we have environmental impact assessment under National Environment Act. It has given public to comment on big projects. What are the social and environmental impacts of that particular project? So people can comment. As far as I know, this is this is the only place where people can participate in environmental decision making. And as we talking about the fundamental rights, if fundamental right get violated, you can go to Supreme Court under Article 126 and Article 17 of the Constitution, which is directly question about the executive and administrative action. And also, we can go to the Supreme Court in relation to fundamental rights violation cases under public interest litigation. This concept is really important because in environmental cases, as Center for Environmental Justice, currently we are handling lots of cases under this public interest litigation concept. There you don't need to the definite or the exact victim of that particular environment issue, because just because of you are a citizen of Sri Lanka, you can go to Supreme Court and question the environmental degradation or environmental issues which is taking place in Sri Lanka. So next I want to move into case laws in Sri Lanka. You know, when you talk about Bulankuluma case, this is really important, and this is many of people talk about this Bulankuluma case when it comes to environmental protection and sustainable development, because this important case has set legal rules for environmental law, covering things like public trust doctrine, sustainable development, and safeguarding the environment. And while considering the fundamental rights, it follows the principles from Stockholm Declaration, Rio Declaration, and also this Bulankuluma case emphasizes the public has the right to object and that proper legal procedures must be followed for the development project. And also, when we talk about this Wattegedara Vijayabanda case, it is also really important. And I have quoted this statement or part of judgment. This statement explained that the right to use the environment responsibly and conserve it is acknowledged globally and in Sri Lankan national law. And also, it has mentioned that environmental rights is a fundamental in the fundamental rights section. The right to clean environment and principles of fairness between generations in protecting the environment are impiled under Article 12(1) of the Constitution. We can't forget Chunakam case when it comes to sustainable development and the environmental human rights. Especially, it has been talked about the deprivation of clean water is a violation of right to equality under Article 12 of the Constitution. So I was asked to discuss here most recent cases or recent environmental cases. So I chose one case, which is ICFR 168/21. I want you to bring your attention to this. You can see it through this picture, or you can already know that Express Pearl case. It caused a big marine disaster. It's in Sri Lanka, and this disaster not only impacted the livelihood of the coastal communities and the public health, but also violated the right to a clean and healthy environment for the present and future citizens. In response, there have been taken efforts, including CJ litigation, to seek a compensation for the damages and in affected beaches and also support the affected fisheries community. Getting justice for the Express Pearl incident is really significant for sustainability, because it holds those who are responsible and accountable, discouraging future negligence. This is not only addresses immediate damage, but also promotes the responsible practices, protect ecosystem, and ensures the well-being of the communities. Contributing to a many sustainable approach, they have to maritime activities, preventing similar accidents. So this is about Express Pearl matter. And also I want to discuss a bit about the climate change case. Climate change case, climate change mitigation can be considered as a crucial part of sustainable development policies to address environmental challenges. CJ filed this case on 23rd of May 2022. Initially, they targeting the former president, and they later expanding it to President Ranil Wickremesinghe and few other government respondents. And this petition aimed to compel Sri Lanka as a UN member, as well as signatory to Paris Agreement, to take concrete steps for the climate adaptation and the mitigation. As a result of this case, on 9th of January 2023, the cabinet ministers decided to enact a groundbreaking Climate Change Act, and it reflects the commitment to address the mitigate and impact of the of climate change through legislations. And also, one of the key ways to achieve sustainable development is the managing or reduction of the waste that is generated within the country. If you can remember, there was a shocking news about this UK waste case, or 2019, they sent 263 containers of clinical waste to Sri Lanka. On 22nd July 2019, the Center for Environmental Justice took action by filing a case against import of clinical waste containers from UK, and the petition not only highlighted the environmental harm and the public health threats, but also they want court to intervene to send the waste back to UK. And also this case was emphasizing the importance of accountability in protecting our environment and citizens. And also there was a huge tragic about this Meethotamulla. If you can recall this tragic landslide at Meethotamulla, garbage dumping in Colombo, it causes number of human or deaths of people, and it damages to the houses of people. Following this incident, CJ filed a case on 2017 against the government waste dumping practices. And as a result of this case, CJ was able to get the approval for the National Waste Management Policy on 2022. So these are the cases that I want you to think about more, and I want to discuss with you, and from the perspective of human rights or environmental human rights and the sustainability. And also, I want to conclude my presentation by emphasizing that we cannot only demand our rights, we need to fulfill our responsibility towards the protection of environment, or to achieve sustainable development through environmental or sustainable way to protect the environment. And yeah, that is our duty as the citizens of Sri Lanka. And thank you. Yeah, if you have any questions regarding my presentation,
Thank you, Ms. Thushini and Professor Kokila. If you have any questions, you can type in the chat box. And first, I would like to ask a first question. So we are talking about human rights and sustainability today. But do you think the general public of Sri Lanka have a good understanding about their human rights and their responsibilities? So what is your opinion?
Are you asking from me or Thushini?
Professor Kokila, can...
Yes, thank you, Trishan. That's a very good question that we all should ask from all of ourselves, because knowledge on human rights, well, let me put it in this way. Now, through media and social media, we see many posts and discussions, dialogue, discourses on human rights. But at the same time, many reports, many news items on sustainable development. But I think very little knowledge on what exactly mean by these terms and these ideas. But these are very crucial for human development in any society. So there's this problem of a gap between that, it being the most very, very important and very crucial center of the discussion, these concepts. But at the same time, general public do not have, unfortunately, much idea about these concepts. So if you ask me, then what should we do? Yes, this webinar is a good example that to make general public aware of these concepts. So my understanding and my observation is people actually like to learn about these concepts, particularly human rights and sustainable development, because that is at the top level discussion everywhere. So people like to learn, but there are not many opportunities for them to study this correctly and technically. So I think efforts like this, that people can come and join for free and then get the knowledge, are very much important. And I also think that you will publish this on other social media forums as well, which is very, very important and crucial for the knowledge sharing. So my answer for your question is no, not sufficient level of understanding on either on human rights or sustainable development. But I know that people are very enthusiastic about and curious about these concepts. And the most dangerous thing in that entire discussion is that people use these terms and communicate their ideas without knowing exactly what they mean. So I think that there's a danger in this as well, because these are popular concepts. People use it without having the proper understanding of what exactly they mean.
Thank you, Professor Kokila. And another question that I'd like to ask from Ms. Thushini. So I would like to mention that few famous cases, that Bulankulam versus 6 others, Ministry of Industrial Development, and 7 others, means a Paula Postpaid case, and another case, Sugatapala Mendis versus Chandrika Kumartunga, and others, which call Watersage case. And there are many decided cases. And what do you think about the impact on human rights and sustainable development through those judicial decisions?
Yeah, actually, currently, we are handling so many environmental cases, and we are referring, most of the time we are referring Bulankulama and Golf as green case and Chunnakam case as the decided cases in our cases, or the ongoing environmental cases. So that is it, like those cases, through those cases, it has been defined what is sustainable development and what is public trust doctrine, and as well as intergeneration equity and intrageneration equity, and lots of environmental concepts has been interpreted or recognized under these cases, environmental cases. So under our court system, most of we don't have lots of environmental cases in our courts. It is really we have really limited cases, environmental cases in courts, and as not like criminal and civil cases. As a result, it is really important to cite these environmental decided cases. But still, I want to say, like, there's a lack of I would say it's a usage of the environmental principles recognized under these cases. Yeah.
Thank you. And there's a question from Ms. Samadhi Hansen. I think she has raised her hand. You can unmute and speak. Ask your question.
Thank you for the opportunity. First of all, I would like to thank Professor Kokila and Ms. Thushini for the very informative lectures they conducted. I expect an answers for my question from Professor Kokila. Professor, some states granted the right of nature, and on the other hand, humans should go to court for the right of nature representing the nature. So I would like to know from you regarding the possibility of establishing this right of nature concept in Sri Lanka. And my second question is, are right of nature and giving legal personality to the nature the same concept or two concepts?
Okay. Yes, there are three queries in your two questions. Thank you very much, Samadhi. Thank you very much for raising that questions because I think this is a very good platform to do this discussion. So let me first come to your first question. You mentioned that the difference between the legal personality and rights of nature.
Yes, ma'am.
Yeah. What is the first question? I forgot that.
The first question is, ma'am, possibility of establishing the right of nature concept in Sri Lanka.
Okay, right, got it. Thank you. Now, Samadhi, this is like this. Now, rights of nature concept has enormous room for development. It is just emerging as a global discourse. If you look at Sri Lanka, we even do not have guaranteed right, constitutional guarantee for right to clean environment, not at least a fundamental right to clean environment. So we have to go a long way if we are going to meet with the this rights of nature concept. Let alone rights of nature, we don't even have a human right, fundamental right to clean environment. So this human rights perspective of environmental protection, even though, like Thushini mentioned in several cases, even though like they are they have done enormous service to the development of environmental jurisprudence in Sri Lanka on this human rights perspective on environmental protection. Still, I think Sri Lanka has to go a long way establishing right-based approach to environment. So I do not see a green light in the near future where the rights of nature is guaranteed by the Constitution or coming as a provision in an act passed by the Parliament or a judgment by the judiciary. Not in the near future, perhaps later on. Because we need to establish this legal, this right-based approach to environmental protection, stable, and then we can move on to rights of nature concept. So in Sri Lanka, I don't think that in the near future, there will be a concrete provision, well-established concept within the Sri Lankan jurisdiction. But let me tell you, I'm a member of the national consultant for the committee to draft national policy on living entities. So the Ministry of Environment is, at the moment, they are developing this concept of living entities. So we are drafting a national policy on living entities, which is a positive sign. So the ministry representing the environment have taken the steps, and also the executive branch of the country has, in consultation with the executive branch of the country, now this whole idea of living entities moving forward. But it will be only a policy at the moment. So let's see. There can be some positive impact by these initiatives taken by the government to ensure the living entities are right. Second question you asked is that are the rights of nature concept and granting legal personality similar or different? Well, that is the way they look at the issue, as well as what would be the outcome. What is your expectations by granting rights of nature? Now, by granting rights of nature, Samadhi, one can argue that it is just a conceptual framework that we are looking at, just like ancient time we worship. We see the natural objects as divine some concept. So it's just a general acceptance of nature as a living being. But as lawyers, what do we expect from this concept? We expect some kind of a guarantee. So where do we do the guarantee? Through legal provisions. In order to guarantee the legal provisions, where should we go? To courts. So unless the nature can go before the court claiming the rights, what is the purpose of having rights of nature guaranteed? Therefore, I think legal personality comes as the second stage. First, we should guarantee and establish the rights of nature discourse, but definitely it should be followed with the guarantee to appear as a legal person seeking the justice before the court. And also, in other jurisdictions where they have ensured this through statutes and constitutional provisions, what they have done is they have appointed legal custodian. In Wanganui River case, Maori indigenous group has been appointed as the legal custodian of Wanganui River in case if the river wants to go to court seeking justice. So there can be some alternative arrangements, because at the end of the day, this judicial process, this legal personhood concept itself is anthropocentric. That is man-made. That is human focus. So the rights of nature scholars now are further exploring to have not legal personhood, but legal naturehood. So these are too early to having debate within the Sri Lankan context, but at least we are now in the process of drafting a national policy on living entities, which is a praiseworthy effort. But let's see. I think this is clear now. Did I answer your question, Samadhi?
Yes, ma'am. Thank you so much.
Okay.
Yeah, there's another question from Professor Niranjani, Professor Kokila. Can you please briefly explain the difference between fundamental rights and human rights?
Yes. Let's take this as the international law, human rights and fundamental rights when you come to the national level, domestic framework. Now, human rights is the rights and let's say the rights that is guaranteed by the international instruments. So whatever the rights and justice framework and also the freedom, liberty, justice, rights guaranteed by international instruments are called human rights. For example, United Nations Declaration of Human Rights, UDHR, and also International Covenant on Civil and Political Rights. These treaties, conventions, agreements at the international level, there is a spectrum of human rights that is guaranteed. So for any human being born as a human being is guaranteed that these set of human rights should be safeguarded for that human being. For example, right to life, freedom from torture, and right to privacy, right to family, right to education. All these rights are human rights. Now, what are fundamental rights? Fundamental rights are the scope of, or the number of, or the portion of human rights that is incorporated into one's constitution or any other legal framework at the national level. If I take the example of Sri Lanka in 1978 Constitution, Chapter 3 is the fundamental rights chapter. So whatever the rights from Article 10 to Article 14 guaranteed in Chapter 3 of the 1978 Constitution are fundamental rights in Sri Lanka. Whatever the rights explained and guaranteed at the international level through Convention Against Torture and Child Rights Convention, CEDAW Convention, ICCPR, UDHR, all these human rights conventions, treaties guarantee human rights. Now the next explanation. All fundamental rights are human rights, but not all human rights are fundamental rights because the country, according to the state sovereignty, decide what are the human rights that can be guaranteed in a particular jurisdiction. In Sri Lanka, Chapter 3 of the 1978 Constitution says, what are our fundamental rights?
Thank you so much.
Okay,
thank you so much. That's very, very clear to me. Thank you.
Okay, Niranjani, my pleasure.
Okay, and another question from Mr. Jayawardena. Natural resources are provided to some selected persons at a very low rates while imposing heavy taxes on basic human needs. What do you think about this situation with regard to equality?
Well, equality as a fundamental concept subject to limitation. Equality can't be guaranteed limitlessly for everyone. So there can be limitations. Limitations are also explained in the Constitution under Article 15. So whatever the provisions that I just mentioned under Chapter 3 from 10 to 14 are subjected to limitations in Article 15, except Article 10 and 13. Sorry, 10 and 11. They are non-derogable rights. They can't be limited. Article 10 is right to conscious and right of freedom of religion. And Article 11 is freedom from torture, inhuman, degrading treatment or punishment. So these two are non-derogable. They are not subject to any limitation, but the rest is subject to limitation. Equality comes in Article 12.1, and that is subject to limitation. And Article 12.2 states that non-discrimination, so no citizen shall be discriminate or treat differently on the basis of race and sex and age and all of those categories that I just mentioned in my PowerPoint. So no one should be discriminated. Article 12.2. But Article 12.4 states that women and children and people with disabilities can be treated differently. That won't violate Article 12.1 or 2. So you have to understand that true, that equality means that everyone should be treated equally. But the state can decide limitations on equality provision. So equality does not mean that everybody across the board should be treated equally. It means equality should be ensured within the equal people. So what is that criteria of equal criteria, standard that you are looking at can be varied. For example, in USA, there is this case called Browns versus Board of Education, where we all know that in America, there's this color segregation, and the black people were treated differently to white people. Black people have separate compartments in the public railways, where the white people have separate compartments. So no one is allowed, the black people were not allowed in the white compartments. Likewise, even school admissions were based on color. So this was challenged by this case, and then there was this judgment, this case, and there's another judgment following up, states that equality means among the equals. It is not equality for all. So there can be criteria that the state can decide to differentiate. So that space is there, that room is there to differentiate. So in your question that natural resources are subjected to natural resources are provided to some selected persons at a very low rates while imposing heavy taxes on basic human needs. Well, one can argue on purely legal basis that, well, that is the difference that the government or the state can impose upon us. But that is theoretically. But if you ask my personal view, this is very much visible in the Sri Lankan context, what you just mentioned. And that should not happen. And that should not be guaranteed within the law. Whatever the efforts that should be, that should impose different people on different basis, that should not happen. And I think that is against the law and violation of equality provisions in the Constitution.
I have a question to Ms. Thushini. With regard to the IEPSL case, so can you elaborate more about the contribution to the sustainability and human rights through that case?
Yeah, actually, through that IEPSL incident, you know, we lost lots of like our entire beach was polluted because of that plastic pellets and the chemical substances. So we can say it's a very greatest marine disaster happens in the world. So through that, we as CJ, we went to court and questioned, like, this is not only affect to the beach of or the marine environment of Sri Lanka, but also it affect to the livelihood of the people, or it affect to the fishery community. If you can remember, there was a period that we can't eat fish, just that because of that incident. They were saying that fishes got that kind of the fishes got poisoned because of the chemical substances, and it's a kind of our consumer rights. It's about our consumer rights, as well as people who fisheries community. When we talk about the fisheries community, they can't engage their occupation, and it affects their right to occupation, as well as this is not only it is affect to our future also, because still there are plastic pellets, they are cleaning beaches. We can't say this is a kind of temporary issue, but it affect to the future of the country, as well as the environment of Sri Lanka. So this is about it is affect to the right to equality, right to occupation, and right to live in a healthy environment. There are many rights has been affected through this incident. Trishan, could you please just mention, like, raise your question again?
I couldn't hear it. So yeah, that's what I wanted to ask from you. And there's another question. What is your idea about the climate financing? Is it very popular in nowadays, and do we have to have a proper plan to practice in Sri Lanka?
Could you please repeat the question, because Trishan?
What is your idea about the climate financing? It is very popular in nowadays, and do we have a proper plan to practice in Sri Lanka?
Yeah, like climate finance. Professor, do you have any idea about this thing?
Yes. Climate financing has become with the economic crisis in Sri Lanka. I think this is like a rainbow in the rainy sky. The climate financing is coming into the picture, and everybody is very enthusiastically exploring the possibilities of make use of this climate financing. Now I see two sides of this. One side is the narrow sort of focus that to overcome the difficulties in this economic crisis, that we can use climate financing in a way that, as a developing country, as well as the country is suffering enormously with economic problem, that one can say that it's a feasible and very practical solution. So I'll put that aside and let me focus more on the other side. That is, climate financing is very much relevant to my argument in this whole entire discussion today, that is equality, equity, fairness. So historical guilt is upon the Western countries, the northern industrialist countries, for using overutilization of natural resources during the Industrial Revolution. So they have a responsibility, and also they have a duty towards the developing countries to support their developing process. because more and more limitations on their development process due to climate change effect. So least carbon emission is monitored, and then the developing countries, particularly emerging economies, BRICS countries, Brazil, China, South Africa, these countries, India, these countries are facing many problems and restrictions by the North. So then the equity, fairness, justice problems arise with sustainable development. What do you mean by sustainable development? Is it only the development, or can we save our environment and then win development goals as well? So these are the problems in the developing countries at the moment. But for the North, for the industrialist countries, they have gained development, but they can't enjoy that because now we have this climate change problem, challenges. The changing of weather, changing of seasons, extreme weather is affecting America and other parts of the world to a greater extent. So now their problem is how to slow down the carbon emission and how to limit the carbon emission from the developing countries. So this inequity can be mitigated through climate financing. So the North or the industrialist countries have a duty, and more commitment, more financial commitment should be made towards the developing countries. So on that side, I think that's a justified argument, legitimate argument by the South, by the developing countries, that they need climate financing. So recently at COP28, the president of Sri Lanka presented this idea of climate justice forum, where they bargain more climate financing and more technical support, more technical assistance and expertise coming from the North to transfer from North to the South, which is, I think, a legitimate request. So I think climate financing request North to provide more financing mechanism towards South, financial transfer towards South. European Union is complying to a certain extent with this, but there are certain incidents. Recently, Germany have restrictions on climate budgets. So then they found it very difficult to move forward with climate budgets. Due to the economic crisis that is making an adverse impact all across the globe, now more and more restrictions on climate financing, but the South has all the legitimate grounds to apply for climate financing, and the North has the duty to provide more financing towards the South.
Thank you, Professor Kokila. And we are going for our final question of the day. This is to Ms. Thushini. You mentioned about the case about climate change mitigation and adaptation in the Supreme Court earlier this year. Was it compelling the government to take action as we are the party to the Paris Agreement? This is from Professor Niranjani.
Yeah, thank you. Actually, we mentioned it in our petition because in 2016 we have signed the Paris Agreement by binding to get actions to mitigate the climate change and adaptation of climate change. So that is one of our main reason to file this case, and we want to do something against climate change. So yeah.
Can I ask Trishan? Can I continue the question?
Yes, sir.
Yeah. So it was CEJ. You filed a case against the government, is it?
Yes. Yeah? Yes, we have filed case.
And the judgment was given?
No, not yet. It is ongoing, but still they have given their attention to draft Climate Change Act, and they have taken some initiatives to address the climate change.
All right. Yeah, because I was checking the internet. I couldn't find anything on a judgment. So you filed the case in.
It's ongoing.
Okay. Right. That's great. Thank you.
So are there any other questions? So I think with the time, I would like to thank our two speakers, Professor Kokila Konasinghe and Ms. Thushini Jayasekera, and all the participants who joined through the Zoom and Facebook Live. And this webinar will be available on YouTube channel soon. And I would like to thank President and the Council members of IEPSL, and especially the Academic and Examination Standing Committee of IEPSL, and Mr. Janak Jayasekera, who organized this valuable webinar, and all the members of Marketing and Communications Standing Committee for their support. And thank you all for your participation, and good night.
Thank you very much.
So much.